Hello, my name is Heather Heemstra. I'm a sophomore here at PBA and I'm an accounting major.
Hi, I'm Ruby Zemer. I'm also a sophomore here at PBA and I'm a marketing major, and we're both students in Dr. Webb's Business Law 1 class. And today we're going to be discussing Sherbert v. Verner, a 1963 case that made its way through the Court of Common Pleas, the South Carolina State Supreme Court, and eventually the United States Supreme Court. And this case tackles work and religious obligations along with the free exercise clause of the First Amendment.
Today, I'll be specifically discussing the parties of the case and the basic facts of the case.
And I'll be discussing the legal issues relevant to religious freedom.
And then we're both going to be discussing at the end whether we agree or disagree. Here are the parties of the case. First, we have the appellant, Adele H. Sherbert, and then we have the defendant, Charlie V. Verner, as members of the South Carolina Security Commission and Spartan Mills. Here are the basic facts of the case, specifically taking a look at the background. So this case was argued April 24th, 1963, and it was decided June 17th, 1963. So Sherbert worked at a Spartan Mills textile plant. She worked the usual work week, Monday through Friday. And then after 19 years of working at this textile plant, Sherbert decided to become a Seventh-day Adventist. And a key part of this religion was to keep Saturday as a Sabbath day, meaning to not work on Saturdays. Now, this had not been a problem originally, as she was only required to work Monday through Friday. But then the mill that she was working at decided to make Saturdays a required work day, which conflicted with Sherbert's religion and her religious beliefs. Sherbert explained her religious beliefs to the mill, and so she requested to be excused from working on Saturdays. And the mill ultimately denied her request and fired her after she had worked there for 35 years. Sherbert then sought new employment, but couldn't find any jobs, as all those new jobs that she was trying to apply to required her to work on Saturdays, which she refused from doing so due to her religious beliefs. Sherbert then filed for unemployment compensation benefits under the South Carolina Unemployment Compensation Act. And to be eligible to receive these unemployment benefits, you had to be deemed able to work. And the commission denied Sherbert due to her denying other jobs at the textile mills. Sherbert then explained to the commission that she had denied these other jobs due to her religious obligations and her religious beliefs, but the commission still denied her request for unemployment benefits, as they did not believe that these religious obligations were a good enough reason to be denying other jobs. The basic facts of the case continued, now specifically looking at the legal battle. So Miss Sherbert went to the Court of Common Pleas for Spartanburg County, and the judge ruled against her. She then appealed to the state Supreme Court, and they affirmed the prior court's decision. And then she appealed to the United States Supreme Court, who reversed the judgment of the South Carolina Supreme Court. Now, specifically, Ruby will be discussing the legal battle of this case relating to religious freedom in the next slide, and we'll be going into more specifics.
The legal issue that the courts were looking at was whether the South Carolina law, which denies unemployment compensation to Seventh-day Adventists who, because of her religion, has declined to work on her Sabbath, is a law prohibiting the free exercise of religion as those words are used in the First Amendment. The first question that the South Carolina courts asked was, does the disqualification for benefits impose any burden on the free exercise of the appellant's religion? Or in other words, did the denial of unemployment benefits by the State Unemployment Commission impose a burden on Ms. Sherbert's right to freely practice her religion, which recognizes Saturdays as the Sabbath? The second question that the courts looked at was, does this denial violate the free exercise clause? Looking further into that second question, we can see that the courts were asking, does this imposition on Ms. Sherbert's religion violate the free exercise clause of the First Amendment? Or in general, does the denial of work compensation benefits to those exercising their religious beliefs impose a burden on that individual's First Amendment rights? The First Amendment Free Exercise Clause states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Looking at the question, did the denial of unemployment benefits by the State Unemployment Commission impose a burden on Ms. Sherbert's right to freely practice her religion, which recognizes Saturdays as the Sabbath, we can look at the Seventh-day Adventists who on the Sabbath tell religious members to not participate in secular activities or work. They see this time as a designated time for religious rest and rejuvenation. The Sabbath falls from Friday at sundown until Saturday at sundown, where Miss Sherbert was asked to work on Saturdays. Because of this, the Supreme Court ruled in a 7-2 decision that because the denial of unemployment compensation imposed on Miss Sherbert's right to freely exercise the Sabbath, that this denial was also in violation of the Free Exercise Clause of the First Amendment. So, looking at the court rulings of this case and relevance to religious freedom, we can look at the rulings for the Court of Common Pleas, the South Carolina State Supreme Court, and the United States Supreme Court. In the Court of Common Pleas for Spartanburg County, they sustained the Commission's argument that disqualifying Ms. Sherbert compensation did not abridge her right to practice her religion freely, and the South Carolina Supreme Court affirmed this judgment. Ms. Sherbert appealed to the state Supreme Court, which held specifically that the appellant's ineligibility infringed no constitutional liberties because such a construction of the statute places no restriction upon the appellant's freedom of religion, nor does it in any way prevent her in the exercise of her right and freedom to observe her religious beliefs in accordance with the dictates of her conscience. Ms. Sherbert appealed to the United States Supreme Court, and her case was heard. And Mr. Justice Brennan held that South Carolina could not constitutionally apply eligibility provision of unemployment compensation statute so as to deny benefits to a claimant who had refused employment because of her religious beliefs, which would require her to work on Saturday, which, according to the Seventh-day Adventists, is the Sabbath, a day of rest and rejuvenation. Looking at the legal issue in the court's 7-2 ruling, we agree with the U.S. Supreme Court's decision that the denial of unemployment compensation by the state unemployment commissions violated the Free Exercise Clause. And the Free Exercise Clause states, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. Denying unemployment compensation would put Ms. Sherbert in a disadvantage financially, and from our perspective, that is seen as a financial punishment for practicing the Sabbath, a day of rest according to Seventh-day Adventists. And in other words, this denial prohibits Ms. Sherbert from practicing her religious beliefs as she is put in a financial disadvantage, a direct violation of the Free Exercise Clause.
Christians, we value Sunday mornings as a day of rest, worship, and fellowship. And we believe that we have the right to reserve Sunday mornings to church and to honoring God as Christian individuals. Exodus 28 says, Remember the Sabbath day to keep it holy. 6 days shalt thou labor and do all thy work, but the seventh day is the Sabbath of the Lord thy God. This summer, I worked at a river tubing company, and they actually had asked me to work on Sunday mornings. And I told them that I had a religious obligation and that I go to church every Sunday. And fortunately, they understood that. But due to my religious beliefs, that's why I agree with the Supreme Court's ruling that it's unconstitutional to deny Ms. Sherbert unemployment compensation due to the Free Exercise Clause.
I'm personally looking into real estate either senior year or post-graduation because it's a career where I primarily make my own schedule, and I can avoid my religious freedoms being imposed on and can emphasize the importance of church on Sundays, especially when I'm older and have a family.
In 1990, this case was overruled by Employment Division v. Smith, which ruled that the Sherbert test was too broad as applied to generally neutral laws on work compensation and religious obligations. However, we disagree with this overruling, and the 1990 case has caused controversy over religious freedom. Here's our bibliography with the sources that we used. Thank you so much for watching.
We hope you enjoyed our presentation.